Hi, I'm Paul Peterson.
I'm Chris Sun Liu. Part 2 of Civil Liberties 1, we'll be looking at some of the rights of the accused. Professor Peterson, what are some of the key rights of suspects that are protected by the Constitution?
Well, I'd say the four most important are the right to be secure against unreasonable searches and seizures, the right not to be forced to incriminate yourself, and the right to an impartial trial, and the right to legal counsel.
Let's go down that list one by one. What rights do the American people have in terms of dealing with searches and seizures?
Well, Chris, in the Fourth Amendment to the Constitution, part of the Bill of Rights, it says that the right of the people to be secure in their persons, homes, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause. There has to be some reason to search your house.
As with the case with the rest of the Bill of Rights, as we talked about in Part 1, this was thought originally to apply only to the national government. So when was it decided, if ever, that this applied to state governments?
Well, the key period in American history when many of these rights of the accused get applied to the states very clearly happens during the Warren Court, the court of Earl Warren. And that, in this case, it was Earl Warren who decided with his fellow justices that search and seizure protections applied to the states in the very important case Mapp v. Ohio, decided in 1961. And the key thing that the court decided was that if the police did not have a valid search warrant, the evidence obtained when they gathered that, when they entered that house, could not be presented before the court. And so a person, even though they were guilty, could not be convicted because the evidence couldn't be presented before the jury. So that is a selective incorporation of this provision of the Fourth Amendment to the states. Now, Earl Warren was previously Attorney General in the state of California. And when he is appointed by Eisenhower to the Supreme Court, I don't think that anybody realized that he would be such an important Chief Justice. But he is the Chief Justice who hands down the Brown decision, begins the civil rights movement, and he is the key figure in many of these civil liberties cases that we're going to be discussing.
The story of Earl Warren is an interesting and important one. He really shifted public policy in a civil libertarian direction. But did the court that followed him continue this trend?
Well, they were very much influenced because of the principle of stare decisis, which we've talked about before. But it does begin to qualify the decisions of the Warren Court. So it doesn't really overturn the Warren Court. But the Burger Court, when Warren Burger becomes Chief Justice in 1969, and he is now was appointed by Richard Nixon, and he begins to move in a more conservative direction, just as the public is moving in a more conservative direction as part of the backlash after the civil rights movements and the racial violence that takes place during 1967, 1968.
So, regarding search and seizure rights, the Warren Court hands down Mapp v. Ohio. How does the Burger Court back away from this decision?
In a case called United States versus Leon, an officer believes that the search is valid. He thinks he has a search warrant, but he really doesn't. And so it is decided by the Burger Court that since it was a mistake and not an ill-intentioned mistake, that Mapp v. Ohio did not apply in this case. So you can see it's a qualification of the Mapp v. Ohio search and seizure protection. And then there is a case decided much later, but also by a more conservative court than the Warren Court, New Jersey v. TLO, where it involved students' lockers at school. This is in a high school. Somebody is thought to be using marijuana, and the lockers are searched, and it turns out that this indeed was in fact the case. And the question was, is the student's locker at school the same thing as your home? And the court said no. So Map v. Ohio is still law. It still is protecting people. If the police come into your house and they deliberately seize your property and search it, and they don't have a judicial warrant, well, then that evidence cannot be presented in court. But there are qualifications on it that have been placed on the court since the Map v. Ohio decision in '61.
And what is the current thinking on the court about this issue of searches and seizures?
Well, in 2014, the Supreme Court handed down an amazing decision, and it was a unanimous decision. And the case is Riley v. California, and I think we're going to be talking about Riley v. California for a long time, even though it just was handed down in this year. Riley was arrested when loaded guns were found in his car. Police searched through his text messages, photos, and so forth, and based on that, they charged him with a local shooting. But the court ruled that search and seizure of your cell phone and the digital data on that cell phone without a warrant is unconstitutional. So Chief Justice John Roberts writes, modern cell phones are not just another technological convenience. They hold for many Americans the privacies of life, worthy of the protection for which the founders fought. So that is an expansion of Map v. Ohio to a completely new domain, and it's made unanimously by 9 justices from the most liberal to the most conservative on the court. It's a pretty big decision.
Professor Peterson, how would you sum up the right of Americans to be secure against unreasonable searches and seizures?
Well, we have had selective incorporation of the Fourth Amendment in Map v. Ohio. It's never been changed. In fact, it's been expanded in the recent Riley decision, but there have been some qualifications placed upon it by the court after that came into power after Warren passed from the scene.
Let's turn to the next right of the accused on our list, the right not to self-incriminate. What is this all about?
Well, that's this Third Amendment. And in the Third Amendment, it says, nor shall a person be compelled to be a witness against himself. Well, that's taking the Fifth. We've all heard about people being read their Miranda rights. Well, the case is Miranda v. Arizona, 1966. It's once again the Warren Court. It's once again the high water mark of the civil rights movement. The court hands down a decision that says you must be read your rights before questioning, or the evidence is going to be excluded. So they do the same thing as they did in the search and seizure case, the Map v. Ohio. They say, okay, if the police misbehave, they can't present that information in evidence before a jury. Now, that too was qualified by the post-Warren Court, by the Berger Court, in 1971 in Harris v. New York. And in this case, it was said that evidence may be introduced in court if the accused testifies in his or her own defense. So in other words, if you dare talk in the courtroom, which is one of the reasons people who are charged with a crime seldom talk, then it does open up the door to the presentation of evidence that had been collected before a person had been read their Miranda rights. But Miranda is reaffirmed in 2000 by the Rehnquist Court, a very conservative court, but they had an opportunity to overturn Miranda, and a number of justices thought that it probably should have been overturned, but they were unwilling to depart from the principle of stare decisis. So once again, Miranda is still on the books.
The third suspect right on our list is the right to an impartial jury. How does this develop?
Well, in this case, there was an amazing case in Ohio, which eventually becomes the movie The Fugitive. And it involved a doctor by the name of Sam Shepard and his wife, and the doctor was accused of murdering her, and it got unbelievable, sensational coverage. He was later found innocent, I believe, or at least he was released from jail. I think it was concluded that he was innocent, but he was really trumped up charges, and tremendous anti-Shepard press affected the trial. So the court decided in Shepard v. Maxwell in 1966. And the amendment to the Constitution that comes into play here is that a speedy and public trial by an impartial jury is what an accused person has a right to. Well, he got a speedy trial, but was the jury impartial? And the decision by the court was that all this publicity did in fact contaminate the thinking of the jury. Once again, this right of the accused that was applied to the states through selective incorporation of the Sixth Amendment via the 14th Amendment in Shepard v. Maxwell has been limited by the post-Warren Court in a number of ways. It's now said that you can have a lot of publicity. It's pretty hard to stop it from happening. But there are certain procedural safeguards that if you put them into place, the jury will still be regarded as impartial. So here are some of them. One, postpone the trial until the publicity subsides. So you depart from the speedy trial in order to get an impartial jury. Two, the judge instructs the jury to ignore the outside information they might have obtained. They should only pay attention to the information presented to them in court. The jury may be sequestered during the course of the trial, so they can't hear about the coverage the trial is getting outside the courtroom. So that means that jurors may be put into a situation where they can't communicate with their family for a sustained period of time. And then finally, you can change the trial venue. You can move it out of state, move it to a different part of the country where there hasn't been as much publicity.
Last but not least, all suspects have the right to legal counsel. What is this right about?
Well, of course, everybody has had the right of legal counsel, but the question is, what if you can't afford it? And the Sixth Amendment gets applied to the state in an important way in Gideon v. Wainwright when the court decides that if you're too poor to have your own attorney, a public defender must be appointed who will defend you. And that right is still in place today, and that's never really been qualified in any significant way. The big argument that takes place today is whether public defenders really are as good as a private attorney. And public defenders claim they are, but they're also very busy, and whether or not they can really afford the detailed protection of the accused that you can get from a private attorney has been an issue out there. But Gideon v. Wainwright, 1963 Warren Court decision, major decision of selective incorporation of the Sixth Amendment.
Professor Peterson, are there any rights of the accused that are currently on the public agenda?
Well, this issue never goes away, Chris. There's always new wrinkles that come along, and now the biggest one has to do with people who are captured outside the United States and brought to the United States. Do these foreign individuals, usually alleged terrorists, have the same rights under the Bill of Rights as do citizens of the United States? And that's not an issue that there's agreement on between the two political parties. The Bush administration said, no, these are foreign terrorists, and we can bring them to Guantanamo, and we can try them in military courts, and we can hold up the trial for as long as we want. Now, the Obama administration has said, no, they should be trialed in civil courts, and they should have the same rights of the accused as if they were an American citizen. So, a recent example of this was when a terrorist was captured on the high seas, and the question was, Does he need to be read his Miranda rights, or can we get information about the kinds of relationships he's had with other terrorists before reading this individual his Miranda rights? And the decision was made by the Obama administration to take a long time for that boat to reach the United States, and during that period of time, the Miranda rights were not read and information was gathered as best they could. But once the boat docked in the United States, then the accused was read the Miranda rights, and the accused is to be prosecuted in civil courts. So that's an ongoing political issue.
That's it for part 2 of Civil Liberties 1. Our third and last part will be on free speech.